morning, good morning.
Excuse me.
Good morning, namaste. Have a seat, have a seat. Namaste. Have a seat, please.
Yeah, it's a Yashwantrao Chavan Law College.
Oh, I see.
And
Oh, I see.
मालूम कोई पाएगा?
Do me one favor. Can you give me an answer? The question in the back should be very deep.
So this is Professor Bibai. He will introduce about the students. You begin. Let me college.
Yes.
And then the students start.
Yes.
Good morning, sir.
Good
So
morning.
we are from Yashwantrao Chavan. It's a college established in 1978. First and foremost, I am the student of the college, and right now I am professor in the same college. Sir, after Yashwantrao Chavan, the Deputy Prime Minister of our country and the Defence Minister, after him we have named our college in 1987. Our college is affiliated to Savitribai Phule University. Sir, we have permanent affiliation with the university. We have 4 accreditations by NAC and then we are having this like LLB 3 years course, LLB 5 years course, LLM, PhD is the same, and many other diplomas. We are having that with Asian School of Psychology for the psychology diploma. And other than university, we are having the Maharashtra Tax Practitioners Association type for the certificate course in management. So we are having a campus in Parvati. We have 67 acres of campus over there, where APMS Parishad is the private institute with which we are having the institute. And these are the students from different classes.
All from different year?
Yes. And they are the participants in many other competitions representing the college. Most of them are doing good course.
Oh, I see. Very nice.
So this is all of us for you.
Great. So let's start. I said that instead of my delivering a speech, let's have your questions because that will be so much more
So
informative.
they are very much eager to ask questions.
Okay, let's start. So whoever asks the question, please introduce yourself and then I'll answer. I'll be brief so that we can have as many questions. Some tea, black tea would be nice. Black tea you have? But you have tea bag or you have leaf tea?
We have leaf as well.
Okay, then give me some leaf tea. Darjeeling over to Darjeeling. Sure. But no milk, no sugar.
Sure.
Yes. So who wants to start? Huh?
Sir, I would like to say something there. For others, it may be an ordinary morning, but for all of us, this is going to be extraordinary, and I would say this is the best mornings.
Thank you. It's an extraordinary morning for me also. I always feel, thank you so much. Thank you. I feel very elevated in the company of young people. All your faces have so much of enthusiasm and optimism. So it lifts my spirits as well. There is nothing better in life than to interact with, the future of our Indian society, which all of you are. So.
And we are grateful for your generous time and effort.
Oh, it's my pleasure.
It was completely unanticipated.
No, I was very keen to do this. Okay, now, so you're starting and asking the first
Yes,
question?
sir.
Okay.
Sir, it was always my dream to interact with you, and today I'm getting that opportunity. It will be a memorable moment for me.
Thank you. Well, please introduce yourself when you ask the question.
Sir, this
Sit,
is
okay.
I'm Vidhi Lunawat from DLLB 4th year.
So, Vidhi, what's your question?
Sir, today many Indian lawyers found themselves at a crossroad between building a career within Indian legal system or having a foreign exposure at the global level. What's your view in regard to young lawyers navigate this career choice? What should they pursue? Should they go for the global exposure or should they expand our Indian legal career system with them?
The most important thing, Vidhi, is first and foremost to live in the present and try and attain perfection.
No,
Okay.
I'm waiting for that.
The first thing is to be in the present and try and attain perfection in whatever you do. Because by focusing on what you are doing at present, you learn to keep all the noise out of your universe and be focus with a single-minded purpose of excelling in whatever you're doing. Now, therefore, read extensively. Read just not the law but beyond the law, and see what are the, what's happening in the global world, what's happening not just within India but outside India. And the more you allow yourself to be exposed to different ideas, both within India and outside India, the better it is for you. Because in that way, you can imbibe the best of all traditions. Good traditions, good values, good practices, good knowledge is not just confined to, your college or your neighborhood or your state or different states or your country, but globally. So you must imbibe the best. Then you can see what kind of opportunities are coming your way. Foreign law firms have still not formally been permitted to practice in India. Many of them may have informal tie-ups, but there are two broad aspects of the profession. You have the transactional firms which do corporate work. Some of them also do litigation work. Some of them do both. And you have, of course, mainstream court lawyers. So you have to take your pick. If you want to really have a global exposure, I would think that getting a good position in an excellent university overseas for an LLM would open up the pathway of a global exposure. But having said this, it's also important to understand that the job market is always a function of the time. For instance, my young law clerks who went in the past got jobs in the US. They're all doing very well in the US, from private law firms to non-governmental organizations who are specializing in different aspects of human rights and public policy. This year has been a difficult market because of the immigration restrictions in the US. So the US market has been difficult this year. So it really, in that sense, you can't guarantee that you will necessarily get a placement in an overseas firm. But if you ask me what's the difference between the two, it depends on which way you look at it. If being within the system and practicing law in the court is your forte, you have a great career ahead. I believe that the future is for women lawyers and women judges in our system. If you want to join the judiciary by passing the judicial service exam, that's again a wonderful opportunity, where you can serve society as a young judge, and conditions of service are very good even in the state judiciary. If you want to be a private practicing lawyer, well, the sky's the limit. It's how well you perform, and you're constantly then trying to excel. So it's quite a matter of your own personal likes and dislikes, and also your tastes, and also a matter of what opportunities come your way. So if an opportunity is coming your way, be alert to the opportunity, because sometimes opportunities don't keep on coming. When you get a good opportunity, you must say, well, this is my opportunity, I must seize it. But at the least, I would say that don't confine yourself only to my locality, my city, my state. Always travel beyond your immediate neighborhood in terms of at least your mental configuration. Who would like to ask a question?
Good morning, sir. Firstly, it's my honor to meet you. My name is Chaitanya Rausanath. Currently, I am first year BLB student from Akhil Bharati Maratha Shikshan Parishad Station Sohan Law College. Sir, I would just have two questions, sir. So yesterday I was interacting with one of the senior lawyer in the US. She's currently advisor to the Texas Commissioner. When I talked about the various issues, she told that data protection laws in the US are much more stricter than compared to the India. When she was traveling yesterday in the Indian market, the shops are asking for the numbers as well. But in the US, firstly they ask for the customer's consent to give the number. This is my first question. What do you think that should data protection laws in India be more stricter? And Lordship, my second question is that recently I got selected for the National Parliament at the Parliament of India. The same initiatives are taken by the Ministry of Youth and Sports Affairs. Don't you think that similar initiatives should be taken by the Law Ministry as well to engage young law students in the judicial and other things so that they would get more encouragement? Thanks so much.
On your first question, the US is not the most stringent of the data protection countries. It's actually Europe which has a very high standard of data protection. the US prides innovation more than data protection. There are two different ends of the spectrum. One end of the spectrum is innovation, where you allow for innovation. Thank you. You allow for innovation and allow people the full range of creativity, which means that you're going to use data. The other is, of course, you use data, but you protect individual privacy and individual identities. So I believe that more than the US, it's Europe which is really, with the adoption of the global data protection regime, the GDPR regime in Europe, which has been more on the curve of protecting rights. India, of course, we have for the first time some regime for the protection of data, but you are right. I mean, our regime is far from watertight. In fact, that was the source of my dissent in the Aadhaar judgment, because I didn't say that the Aadhaar policy did not have benefits. I recognize that it had benefits, but I felt that the policy did not provide for adequate safeguards of protection of privacy, and that it failed to meet the test of proportionality. India is a very vast country, and we are the source of huge quantities of data, which is the reason why data is so cheap in India, because our data is used. I mean, the users of data are so in a scale. Everything is on such a high scale in India as compared to any of the Western countries, which is one of the reasons why our data on the data is so cheap. Whether you're talking of internet usage or even use of your smartphones, that's the positive. India has done a great amount of work on digital payments, but again, people give away that data as if nothing counts. I can also tell you that sometimes I am myself quite a victim of that, because sometimes you are so keen to get some information, and then somebody asks you on an app for we have these cookies, then if you reject all cookies, manage cookies, and so many times you say all right, accept all cookies, and then you say, well, I could have spent another 5 minutes, another 3 minutes, but we are all short of time. So in a sense, it's a difficult balance to draw. But at the least, I think India must move to data localization, so that the data which companies collect from citizens must be localized and kept in India, so that then you can subject them to more regulatory safeguards. If the data is located in servers overseas, what control do you have with a company which has no real operation in India? The server entirely is based outside India. But I therefore feel that there is a need for us to rethink the kind of data protections which we have, while at the same time not stultifying or not preventing innovation, right? So that's the balance which is to be drawn by the legislatures. Yeah.
So,
I'll just take on and then we
Good morning, sir.
Good morning.
I am Riddhi Parag Malukar from DLLB 4th year. My question is, if the constitution is made to transform the society, what the role should young citizens play in ensuring that the constitutional morality is not just a judicial concept, but it's a lived reality?
First and foremost, it always begins with yourself. That if you have to spread constitutional morality, then you must follow constitutional morality in your own personal life. And what is constitutional morality? Constitutional morality is not something which is subjective or your own private notion of morality, but it's the notion of morality which is based on constitutional values: liberty, equality, due process, fairness. Fairness is the first thing. Tolerance. The Constitution does not use the word tolerance. Tolerance is implicit in the Constitution. It's implicit. Now tell me, which article of the Constitution do you think would imply that as citizens we must maintain a degree of tolerance to every segment of society? Which article of the Constitution will you think of? You tell me.
We were just discussing amongst ourselves, shouldn't it be right to religion?
Absolutely, because our Constitution recognizes that we are a multi-religious society, and tolerance is not just, tolerating, but acceptance.
Yes.
Tolerance is, of course, one way you can say I tolerate. You
Yes.
tolerate even an irritant in the house, right?
Yes.
Or you tolerate an irritating friend. That's not tolerance. Tolerance is basically acceptance
Yes.
of diverse and a plural society. So in that sense, these are the values which shape constitutional morality. Now, it's important that each of us imbibes those values, because one of the problems of the age in which we live today, the age dominated by social media, is that we constantly hear what we like to hear. Social media always, tells you how great you are, and it always feeds you with more information of exactly what you want to read or what you want to hear. So, if, I always find this very interesting. If I like a song, the other day I was listening, day before yesterday in the night, in fact, I was listening to this beautiful Hindi song called Lag Ja Gale. I don't know if any of you like that. And it was, this is a group, I think Soumya Jeet, I'm sure if you Google it, you'll get it. And it was so beautifully sung. But then the moment I finished listening to that song, I had 5 different versions of the same song, which were given to me on my YouTube account. And I said, why do I want to hear the same song over again 5 times sung by someone else? So, in today, because of the AI algorithms which are controlling, YouTube and so many other social media sites that we follow, social media gives you more of what you want to listen to. So if you buy a book on Amazon, you'll get other books of the same genre on Amazon. You'll not get different books. I want to read different books. If I bought a book on the American Constitution, I don't want another book on the American Constitution. I probably want a book on the South African Constitution or on the Indian Constitution. So the reason why I mention this is simply because in times like that today, there's a great focus and responsibility on each of you and each of us as citizens to cultivate a bent of mind which is questioning, which is patient. Hear others. Don't only hear your own voice. Hear others who may have different voices and other ideas. People who conflict with you, people who disagree with you, people who have a different perspective. So I think that's kind of important. Also, civic virtue and civic nationalism is very critical in today's times, because constitutional morality is not about recognizing only your rights or the rights of others, but also recognizing your duties. Our duties as citizens, our duties as a community, our duty not to pollute the environment, and it begins with yourself. If you pollute the environment, how can you expect others to be environment friendly? So you lay down. You should never believe that you are just, after all, one individual who will make no difference to the world. I mean, the world has been changed for the better or for the worse by single individuals, right? So it's the power of the individual to shape ideas, to make the world more livable. So in that sense, constitutional morality is something which is deeply personal, and then in whatever work which you do later on, you can spread the vision of constitutional morality in the way you conduct yourself, in leading by example. So I think the best way to propagate constitutional morality is by leading by example, so that others who look up to you later on in life will find something from you which they can imbibe.
Yes. So
Please say, don't get up, please.
I am Yuvraj Bhagat. I am currently in my penultimate year, and as you said, living in the present, this is a very apparently emergent discipline currently. So, in your experience post-retirement, sir, do you see arbitration in India evolving as a parallel system of justice or as a complement to the constitutional courts? And what risks, if any, does this pose to the development of the coherent legal doctrine?
I'm not sure whether I entirely subscribe to the theory that arbitration is parallel. I do feel that both conventional forms of dispute resolution and arbitration have their own place in the legal system. First and foremost, both litigation as well as arbitration form part of the overall universe of the rule of law, and dispute resolution on objective lines, on efficient lines, with certainty is critical to the rule of law. And therefore you can't really say that these are parallel, because parallel lines, as they say, never meet. Obviously, arbitration and litigation do meet, because arbitration requires the support of courts. They require, our Arbitration and Conciliation Act, say Section 9, is a critical example, a classical example, or Section 11, Section 9 when you move the court for interim measures of protection, or Section 11 when you're seeking a reference to arbitration and the intervention of the court is required. So this is all intervention which is pro-arbitration. Then the final act, there are other areas, for instance, extension of time, or the challenge to an arbitral award under Section 34 on very limited grounds that are contemplated by Section 34. There is obviously this intersection between litigation and arbitration. But there's a critical difference. Arbitration is founded on consent and party autonomy. Litigation and access to the jurisdiction of the court is not founded either on consent or on party autonomy. Section 9 of the Civil Procedure Code provides that a civil court will have jurisdiction over all cases except those which are expressly or impliedly denied to the jurisdiction of the court. So unlike the jurisdiction of a civil court, which is in that sense universal, unless it is accepted by either expressly or by necessary implication, arbitration, the conferment of jurisdiction is only by consent. And because it is by consent, the principle of law is that party autonomy is valued. Because ultimately the parties have chosen an arbitral tribunal of their choice, and therefore they place their faith in that arbitral tribunal. So you will not interfere with arbitral tribunals in their functioning or in their conclusions merely because a different view is possible. That's the critical difference. And to answer your question again and take it forward, I think both have a very valid basis in our society. Courts, because the kind of disputes which they handle. There are some disputes which can't go to arbitration at all. Disputes in rem about the status of a party, the validity of an adoption, the validity of a marriage, the legitimacy of a child, divorce, because these are all matters which are in rem, or the grant of probate of a will. This can never go to arbitration because of the reason, as the classical judgment is in Booz Allen by Justice Ravindran, because these are matters where you're dealing with the status of an individual. Finally, I'd just like to emphasize that as the world is becoming more and more commercial now, and we are now moving to a globalized India as well, where we are increasingly being integrated with the world, either in terms of capital flows, human resources, technology, you'll find that there's a greater scope for the build-up of arbitration. And there are centers across the world. We have some excellent centers in India which are doing arbitration work, whether it's the Delhi International Arbitration Center, the MCIA, then you have organizations like the SIAC, ICC, LCIA. So these are international organizations which are increasingly being used by Indian parties to dispute, to resolve their disputes. So India is not just a net importer of capital today. India is also an exporter of capital and business and technology, right? So Indians are also seeking recourse to the international dispute resolution forums, which would of course open up a great amount of opportunity for young lawyers if they are available. Yes?
Good morning, sir.
Good morning.
This is Apeksha Pawar, studying in the LLB 4th year. So I just wanted to ask, have you faced ever a situation or particularly any case wherein the strict application of law conflicted with your moral conscience? In other words, you felt that the legal outcome would be morally unjust. Sir, as a judicial aspirant, I just wanted to know how do you overcome such situations and uphold the law on rules?
There is not necessarily an overlap between legality and morality, because legality and morality can sometimes be opposing elements in dispute resolution. Now, that causes a problem for the court and for any adjudicator. Do you go by the law or do you go by the morality of an issue? Now, the thing is that when you put legality in conflict with morality, whose models are we talking about? Are we talking about our personal models? Are we talking about societal models? Are we talking of constitutional models? If you're talking of your personal models, then obviously you can't, elevate your own models to the point where you will allow your models to override the legality of the dispute. That a judge, neither a judge, and certainly not a lawyer, can do, because a case has to be decided in accordance with law. The law does give sufficient avenues to allow for considerations of justice to also come in. Now, we always say that justice is justice in accordance with law, and for the reason that when you do justice, that justice is governed by the framework of law in a democratic society. Unless that law is challenged as being arbitrary or unconstitutional, or manifestly arbitrary or violative of the fundamental rights, that's a different issue altogether. But given that a particular law is valid, the rendering of justice has to be within the framework which the law has created. Otherwise, what will happen is, and that's the great danger, that people will start disregarding the law and try to do justice according to their own conscience, which would be a very dangerous thing. So, speaking for myself, I am clearly of the view that when you seek to do justice, or when you approach the court for justice, a case has to, the justice of the case, the justness of the case has to be placed within the framework of the governing principle of law. And that could be a wide variety of laws, whether it's labor laws, whether it is, a service rule, whether it is taxation, whether it is GST, whether it is, the Companies Act, whether it is the Insolvency and Bankruptcy Code. You can't say that, well, I think that this person's a crook and therefore I'll decide according to my conscience. It can't work like that. You may feel that that person is, not exactly a morally just person, or that person is not taking a morally just position. But at the same time, then you have to decide their dispute in accordance with law. On a lighter vein, one of the lawyers who was appearing before me in a labor case, a very well-known lawyer, he mentioned to me once that, he said, well, if I have a bad case, you dismiss my case. He appears for the employers. And he says, if I have a bad case, my case is dismissed. If I have a good case against the employee, I am told to settle the case with the employee. So, that's one way of looking at problems, where you have, say, one segment of society which is less on the balance, has less resources, or is less privileged than the other. Then you will try and see if parties can, because if you know that, if you go to a full trial, this might end in an all or nothing. So you then try and use alternative means in court, like mediation. You try informal mediation as a judge, or bring the lawyers together and say, why can't you resolve this? So in that sense, both parties go happy, and you don't leave one side, particularly a side which is much weaker, with the feeling that they couldn't get justice. Yes.
Good morning, sir.
Good morning.
My name is Betty. I'm from third year. Sir, today I'm feeling so privileged from reading your judgment in the newspaper to meeting you in person. Sir, my question is, in an era where the information is very easily accessible, sir, how can law students develop the habit of questioning, analyzing, and forming the independent judgment, which is essential in the legal profession?
The one thing which is critical to law is that you don't accept the validity of any position that you encounter. That's the one thing about a lawyer, that you never accept something which is stated as a fact. You don't accept it as gospel truth. You always question. If somebody says this is the fact, you will say, well, how do you know that's the fact? Right? If in a criminal case, somebody says that, well, this witness was going at this particular stop, at this particular point, at 11 o'clock in the night. You would not say, okay, he said that, so it must be true. You say, is that believable? What was he doing there? What was the witness doing there at 11 o'clock in the night, close to the scene of offence? Was his presence natural? Was his presence accidental? Was his presence believable? Now, you would also test the validity of that witness's statement on the angle of circumstantial evidence. Is there any other witness who has deposed to that witness's presence? I'm just giving you one example. Likewise, even any other statement, you don't necessarily take that statement. For instance, now the transgender bill which has been introduced. One of the things which the transgender bill does is that while the judgment of the Supreme Court in Nalsa stated that held that one's identity as a transgender is an identity which is established by the self. The transgender bill now says that that identity will be dependent on certification by a medical board, which means you're opening up the individual to an intrusive physical examination by the medical board. So, would you accept this? What is right or what is wrong about this, sort of legislation? I gave you this example for the simple reason that as lawyers, and therefore even as law students, much before you become lawyers, and even after you become a lawyer, your task is to question. Your task is not to become cynical. There's a very distinct line between being questioning and becoming cynical. Somebody who questions wants to test the proposition. Somebody who is cynical has faith in nothing. So, I think it's important not to become cynical, but at the same time retaining the habit of questioning. And particularly, as you said, in times of social media, because even when you read something, don't believe in it. Even if you are reading that 20 times over, because you read something once on social media, you'll get the same thing relayed to you 20 different times. Don't believe it just as something which you must accept with unquestioning faith. You must then cross-check what your information is with other sources of information by the application of your own logic and your own mind, by using your own experience of life on whether this is true or this is not true, because you also see so much of misinformation which proliferates in the name of knowledge, because that's one of the great dangers, that whether it's in terms of food synergies or preferences, scientific knowledge, you'll find that information on all ends of the spectrum floating about, and therefore the burden on you is so much greater to follow the source, question the source, cross-verify the correctness of what is stated. Depending, of course, on how important that issue is. You can't pick out every little issue and spend the next 2 hours on checking it out. But on important aspects of current affairs, on important aspects of current politics, on important matters of legislation, whatever is your interest, whatever is your pathway in life, it's important to in matters which are critical to you. It's important to get exposed to diverse influences and then choose the line which appears correct. Yeah.
Sir, my name is Suresh. I am a second year regular student. Sir, with your permission, before I ask question, I would like to read a few small lines from your book. I was deeply moved by the recently published Why the Constitution Matters.
Why didn't you ask your question?
Sir, my question is associated with this line.
So you just ask the question.
Sir, you talk about the various kinds of silences and sounds in the Constitution. So, what is in general, what are those priority that you take into consideration while listening to those silences or giving sound to those silences?
It's a very important question. So there are silences in the Constitution which open doors, and there are silences in the Constitution which should restrain. So silences don't necessarily point in the same direction of the expansion of principle, but they also speak in the language of restraining power. For instance, there are silences of the Constitution on what rights are comprehended by the Constitution. Article 21 speaks of the right to life and personal liberty. But beyond speaking that no person shall be deprived of their life or liberty except according to procedure established by law, the Constitution has been silent on what you mean by life. The Constitution has been silent on what you mean by liberty. The Constitution has been silent on what you mean by procedure. So these are all silences. And those silences have been opened up by giving life an extraordinarily broad definition, which will include everything by which life becomes meaningful. Likewise, liberty. What is the meaning of liberty? Is it merely liberty from physical restraint? Or is that liberty, the notion of liberty, much broader to encompass a variety of things which you aspire for, including information, access to a clean environment, access to good public health facilities? Is that not a part of life and personal liberty? And procedure. Any procedure is not sufficient. Procedure must be proportional. It must be equitable. So these are silences of the Constitution which open up the Constitution to new applications. The right to privacy. Privacy has never been, in that sense, expressly recognized by the Constitution, but we found that privacy is a fundamental right from the penumbras, as we say, from the shadows of the Constitution. Now, on the other hand, there are silences in the Constitution which would constrain authority, in the sense that how does the governor act when a bill which has been passed by the Legislative Assembly is presented to the governor for sanction and approval? Does the governor have an undiluted discretion? Is the governor really to act on aid and advice? What are the grounds on which the governor can refuse to accord sanction to a bill? And what if the governor refuses to do so and then the bill is passed again by the Legislative Assembly? Does the governor have the discretion? When does the governor have the discretion to refer it to the President of India? Within what period should the governor be asked to act? So these are, in that sense, very critical areas of the Constitution. You will find that similarly, that there are silences in the Constitution in the 10th schedule. The schedule which deals with anti-defection, which don't tell you about what position should be taken in every eventuality which may arise in the political spectrum. So there are different kinds of silences which are spoken of in the Constitution, and therefore the task of interpretation is extremely crucial to give expression to those silences, to ultimately realize the purpose of the Constitution. But how do you interpret a silence? What underlies the interpretation of a silence? That interpretation may be based on constitutional conventions, the convention that a particular authority should act in a particular way. But equally, the ultimate purpose must be to fulfill the broader constitutional purpose underlying that underlying that constitutional provision. Yes?
Just a minute. One last question.
No, we continue. The Chiltna, we are starting at 11 o'clock.
No, so some other people are there.
No, we first, I'm here.
Okay.
I'm focused right now. Yes.
Good morning, sir. This is Arishi Joshi, LLB first year student. First of all, thank you so much, sir, for your precious time. My question is, sir, what is one moral value which always guides you in your life whenever you feel stuck in life? So, if you can share.
The one moral value.
Yes, sir.
The one moral value which I have found very useful when I feel that I need to answer a situation or answer a question. The one moral value is to stay calm. Yes. To not be reactive, and to create a space for myself to reflect and then take a decision. Being reactive, I feel, can result in wrong, hasty decisions. And being calm and reflective is not really a matter of how much time you spend on it. Sometimes, you know, your reflection may require you to spend half an hour. Sometimes you may not have the luxury of even 10 minutes. In the court, sometimes you have to respond in split seconds. But within the time that is available, to allow yourself to let the issue seep into your system. Stay calm, stay rooted, and invoke what lies within you, the power of reasoning, the power of deliberation, and the power of taking a considered decision.
सर बऱ्याच विद्यार्थ्यांची इच्छा असते सुप्रीम कोर्टात प्रॅक्टिस करायची, लॉ विद्यार्थी असो ॲडव्होकेट असो, सगळ्यांची इच्छा असते सुप्रीम कोर्टात प्रॅक्टिस करायची, पण सगळ्यांसाठी ते अफोर्डेबल किंवा प्रॅक्टिकल नसतं. तर 2019 मध्ये एक बिल प्रेझेंट केलं होतं की मुंबईला आपली एक सर्किट बेंच होणार आहे, कोलकाता, चेन्नई अशा ठिकाणी. तर ते झाल्यानंतर ॲक्सेसिबिलिटी वाढेल आणि अजून लोकांची इच्छा पूर्ण होतील किंवा लॉ स्टुडंटची इच्छा पूर्ण होतील सुप्रीम कोर्टात प्रॅक्टिस करायची. तर त्याच्याबद्दल तुमचं काय मत आहे की ते कधी होऊ शकतं, ते स्वप्नच राहील का?
बघा, आता सध्या सुप्रीम कोर्टाने डिजिटल टेक्नॉलॉजीवर इतकं काम केलेलं आहे.
हो,
तुम्ही महाराष्ट्रात बसून, मेघालयमध्ये बसून, तामिळनाडूमध्ये कोण लिटिगंट असेल तिथून ते आर्ग्यू करू शकतात सुप्रीम कोर्टात. मग सुप्रीम कोर्टाचं बेंच करण्याची व्यवस्था याची गरज कितीतरी आता कमी झाली आहे, कारण व्हिडिओ कॉन्फरन्सिंग आहे. तुम्ही केसेस कुठूनही फाईल करू शकता. 24/7/365 यू कॅन फाईल केसेस इन द सुप्रीम कोर्ट. तर पूर्वीच्या काळी कसं असायचं की बेंच नसलं तर सामान्य माणूस तिथे कोर्टात कसं जाणार, आपल्या केसमध्ये काय चाललंय त्यांना कसं समजणार. आता व्हिडिओ कॉन्फरन्सिंगमुळे आपल्याला माझ्या केसमध्ये काय चाललंय, जजेस काय प्रश्न विचारतायत, वकील काय त्याच्यावर युक्तिवाद करतायत, आणखी त्याचा निर्णय कसा लागतोय आपल्याला आपण समजून घेऊ शकतो. आणखी एक बघा, दुसरी गोष्ट म्हणजे की यू हॅव मेड अ करेक्ट पॉईंट की तुम्ही बेंचेस केली तर न्याय प्रत्येक राज्यात सुद्धा सुप्रीम कोर्टात जाऊ शकतो. पण एक त्याच्यावर प्रश्न असतो, तो उद्भवतो दॅट एक कुठल्याही संस्थेची एक युनिटी असते, त्या संस्थेचं एक स्वरूप असतं, एकत्रित स्वरूप असतं. तुम्ही जर का 24 बेंचेस केली सुप्रीम कोर्टाची, कारण मग फक्त महाराष्ट्रातच का, मग फक्त केरळमध्ये का, मग तामिळनाडूमध्ये का, मग साऊथमध्ये करायचं, मग कुठल्या राज्यात करायचं. तर तुम्ही ह्या कोर्टाची वेगळी बेंचेस केली तर त्याचं एक अस्तित्व असतं, म्हणजे एक संपूर्ण अस्तित्व असतं ॲज अन इन्स्टिट्यूशन. दॅट मे बी इन व्हेरी ग्रेव डेंजर ऑफ बीइंग इरोडेड. बट यू कॅन सर्टनली फाइंड आन्सर्स टू मेक जस्टिस अवेलेबल टू कॉमन सिटीजन. सुलभ प्रत्येक नागरिकाला न्याय स्वस्त रीतीने, म्हणजे फार पैसे न खर्च करता तुम्हाला सुप्रीम कोर्टात फायलिंग झालं पाहिजे. सो अ लॉट ऑफ these problems can be taken care of by the use of technology. आणखीन तुम्ही म्हटलं की सुप्रीम कोर्टात जाणं शक्य नाही. आज महाराष्ट्रातून सुप्रीम कोर्टात जे वकील प्रॅक्टिस करतायत ते छोट्या छोट्या जागातून महाराष्ट्रातून गेलेत आणि स्थायी झाले दिल्ली. So if you talk to them, you will find that they've gone from smaller towns from Maharashtra and they have done a very remarkable work in Delhi. So in that sense, I think the barriers are far less than they were 20 years ago.
आणि ते डिजिटल प्लॅटफॉर्म खूप चाललेला आहे सर, ई कोर्सच्या माध्यमातून.
Yes.
Good morning, sir. Myself, Chandrachud. I am from BLIT 5th year. From your experience on the bench, what kind of arguments or approach from young advocates genuinely help the court in understanding and deciding a case later?
Good preparation. 1. 2. Good preparation. 3. Good preparation. So make sure that you read the facts of the case very clearly, extensively, if necessary repetitively, because when you are young you will find that you need to read and reread a case to understand it fully. Now, no harm in it at all. Even when you sit in a court, you will find that you're sometimes troubled, you don't understand what is going on in the court. Don't think that's your problem. It happened to me also when I was a young lawyer. You sat in court and you didn't understand what was going on in the court. But when you get more familiar with the environment of the court, you realize that it becomes easier. Second, always be very careful about researching the law properly. And research much more than what is required for that case. Because because it may or may not be useful in that case, but it will help your career in the long run when similar other cases come to you. Third, practice good communication skills. I said preparation, I'm now sort of elaborating on it. Practice good communication skills. Good communication skills are very important. While you make an argument in court, your argument must also appeal. What are you doing? You're telling a story to a judge, right? Not a story which is a fairy tale, a real life story. So you are explaining a story to a judge. What is the judge doing when they write a judgment? The judge is writing a story about the case, about a dispute between a husband and a wife, about a dispute between two business groups, or a dispute on tax between two levels of government, a dispute when the government wants to acquire land. So everyone is involved in the art of storytelling, and you must be able to tell your story properly. Now, it doesn't mean that you have to tell that story as you would write a novel, because you have to put that story in a legal parlance. But take your time and think about how you're going to present the case. While you have a framework for presenting a case in the court, don't feel that I have to only go to my framework. Sometimes the judge wants something very different. You might feel that the judge is asking you something which from your perspective is not very relevant. But the judge has a certain degree of experience in handling those cases. Be honest with the judge. Answer the question of the judge. Judges don't like their questions being ducked because they feel that you're conceding something. Even if it is against your client, face it. There would be an answer, even if that question is against your client. Don't try and avoid the question, because if you avoid it, the judge feels that you've lost the case there. If you confront the case and you tell the judge, but no, there's another perspective, the judge will understand your perspective. So these are some of the, and always be fair to your court, because being fair, being honest in court, I mean, this might sound, almost like an ideal, but as you go along in life, in legal practice, you'll find that there is a huge amount of respect which honesty attracts. And whether it's your opponents, when you're opposing a particular lawyer, you'll find that your opponent will respect you as a person who's always, clear of the line which divides the truth from the falsehood. That you're always, a person to be trusted. There are lawyers whom their opponents know can never be trusted. So that's a terrible reputation to have. So it's how you cultivate your own image in the profession which ultimately counts.
So,
but I'm with the student, they're the future of the nation. I'm happy. Yes.
Good morning, sir. I'm Rajeshwari Reddy from DLB 5th year. So my question is, how does the application of legal principles in courtroom practice differ from how they are taught in law schools, and how can a law student prepare for this difference?
See, the court, the legal principle as it is evolved in courts is very different from the abstract legal principle which is taught in law classes. Each has its value. The danger is when you feel that what is taught in law classes is irrelevant, and you think that all that is taught in the courtrooms alone is relevant. I don't subscribe to that theory. It's important to understand principle as an academic principle also. But when you go to court, you see how that principle is actually applied in the facts of a given case. Look at the principle of res judicata. You must understand what the principle of res judicata says. When a matter in dispute is directly and substantially in issue and has been decided in a previous litigation between the same parties or parties claiming under the same title. Now, in a given case, if it's a land matter, you will see how that principle is being actually applied in the court. So, and court is not just about principle. Courts are also about evaluating, arriving at the truth, about finding facts, cross-examining a witness to arrive at the truth. So there is so much of practical human experience which goes into the unfolding of the truth in the court. I think law classes and law schools must therefore keep pace with that aspect also. Not become so theoretical that you are completely divorced from reality. Equally, courts must also understand that you're not only on the practical side of life, that you must also keep the governing principles in mind. And some of you who will become judges will realize that you have to do both. You have to balance both principle with practicality.
So,
Yes.
good morning, sir. This is Anjali Pandey from NLT third year. Sir, thank you so much for providing me this opportunity. Sir, I have 3 questions.
One because we have to go to others also.
They are related.
But make it one so that we can go to the others.
Okay, sir. The very first, carrying forward the legacy of Justice Y.V. Chandrachud, what really motivated you to join the profession? And the second one, what's the advice you would give to young generation like us to adapt the qualities or the skills required to gain that judicial mind? And third one, sir, when I initially joined law, there was an opportunity running that you yourself is providing internship for these law students. So my question is whether such opportunity is still there or not.
Okay, I'll take your last question first. There are opportunities for internships everywhere. I know of High Court judges who want interns. I know judges of the Bombay High Court have interns. I know Supreme Court judges who have interns. I had interns. I had my own law clerks who would work with me for 1 year, 2 years, 3 years. But we also had interns who would just sort of write and they would be recruited for the month or 2 months that they had time between their semesters. Alright. Then I'll answer your first question. If you want to apply for a law clerkship at the Supreme Court, there's a competitive examination for which you have to study and appear at the examination. The process is extremely transparent and it is objective. So you don't have to have an uncle in the profession who will follow up. I thought that was very wrong, and therefore I completely changed the pattern of recruitment of law clerks. We increase the remuneration. We pay 80,000 rupees a month for young law clerks. Your first question: what attracted me to the profession? I was really attracted to the profession by just the power of the profession to reason. The reason, the contest, the forensic contest, and the ability to search out the truth on the anvil of a forensic contest. I found that as a discipline very exciting. I was also enamored with the profession just by the kind of inspiration which was provided to me by my teachers. Teachers who taught me criminology, teachers who taught us constitutional law, who really created a whole universe. I still remember the examples in contract law, which my professor of contracts, Professor Mulchan Sharma, taught us on the doctrine of frustration. And I still remember the doctrines on privacy, which my professor of constitutional law, Dr. Edabi, gave us, or law and poverty, Dr. B. Shivramaya, or Dr. Lautika Sarkar, who taught me criminology, and which was really the seeds which were sowed in my mind on evolving a more gender equal jurisprudence which I pursued throughout my life as a judge. So that's the second thing. And the third, your second question: how do you cultivate the frame of mind to a judicial frame of mind? I think the critical part to cultivate a judicial frame of mind is to cultivate openness. Never believe that what you think, what you say, what you read is the only correct thing. The paths to truth are varied. Never believe that you have a singular command over the truth or to the best pathway to a case. Think about what your opponent is arguing, anticipate what your opponent will argue, and try and find an answer in anticipation to what may be argued against you. That's the key to success. Yes?
Good morning, sir. I'm Vedant Kashil, final year law student. Considering the modernization of Indian judiciary, is ethical AI integration in legal research is feasibly achievable with current technology? If so, how will it impact the legal profession and practice, and how should we prepare for such changes?
See, ethical AI introduction is a function at 2 levels. The first is in designing AI. Now, AI basically operates on large data sets. What AI does is, in the pre-training stage of AI, large data sets are put together And AI has this remarkable ability to scale up, its ability to process data. And AI model can virtually look at everything on the internet, everything on YouTube, everything on Instagram, and generate patterns. But those patterns don't necessarily provide for an ethical integration of AI. So the first challenge is while designing AI, especially now as we are moving towards generative AI, how do we ensure that the patterns which are detected by AI are patterns which are based on data which is valid, or on data which is not really in that sense manufactured, or data which is not subverted on its own. The second level of the ethical integration is on the part of those who use and apply AI. For instance, the users, as a law student, as a lawyer, how do you ensure that that the AI analysis which you are applying has no data fakes, that that is not generated a fake case? That is your responsibility by cross-checking and by not accepting whatever has been presented to you by the AI model as necessarily the truth. It still needs human cross-verification. Obviously, as time goes on, the level of accuracy will improve. But I was just reading an article yesterday which says that even today, the best AI models, they can't write a good poem, or they can't write a good story, because they're just not trained to do that. Because AI models work on, as I said, they scale up the reading of data and to find out patterns in data. But to write something which is creative, you have to write away from what is generally acceptable, right? You have to write something which is creative, which nobody has thought about. So true creativity in that sense, ironically, may lie outside pure data. Okay, maybe we'll have one question and then I'll go and meet the others, okay? 1 and 2, okay, 2 questions.
One last question.
Okay, one and then one there. We'll come first to you. Did you ask a question? You have asked a question. Okay, you haven't. Okay. One, tell me, what's your question?
Good morning, sir. I'm Jyoti Pandiani from last year BLLB.
Yeah.
My question is, sir, that in 5 years of our law degree, we study a lot about different laws, different institutions, their structures, and sometimes about their anomalies. So, as a very experienced person, what advice would you like to give to the future advocates so as to not be very anxious with such vast knowledge in our career?
I think I'll answer that point by giving you an example from cricket. A team comes to bat second, and now cricket is not a men's sport, it's a women's sport. Yes. Apart from Virat, the one person I really admire is Smriti and Remy. So, your opposing team has made, say, 400 runs. You've come into bat against a score of 400. The wicket is pacey, you are at Perth, the ball is moving around, you have a fast bowler who is bowling good swing and generating good pace. You can't be looking at the 400 every time. You have to bat the next ball. Right? If you keep on looking at the score which the other side has put, the danger is that you're going to be bowled before you make the first run. So the same thing in the law. Never be overwhelmed by the universe. Focus on the immediate. Because understand what is the universe of that case. That case's universe is not obviously the whole universe of law. The universe of that case is decided by the facts of that particular case. So don't be overwhelmed with how much you have to read. Because obviously we are human beings. I mean the field of knowledge is so much vaster than what any one of us can ever dream to master. But that also gives you a sense of humility, right? Therefore never be arrogant that, well, I know everything. When you're a lawyer, you will realize I don't know everything. Because there's somebody against me who has been also paid to have a different perspective. As a judge, you never get into a state of arrogance because you realize that the field of knowledge is so vast. So, but as a practical discipline, focus on that particular present. Don't get overwhelmed by the noise. That noise which is generated even by the information and different statutes. Focus on that. Okay, one last question. Yes.
Good morning, sir. My name is Pakale. My question is, what factors in your view determine whether a young lawyer progress steadily in the profession or stagnates in early years?
See, progress in the legal profession, particularly if you are not in transactional practice. In transactional practice, a law firm will give you a job, you will get a good salary, you will have progress within the law firm, or they might make a horizontal change to go into another firm. If you go to practice in court, the progress is bound to be slow because you are constantly meeting up against people who are more senior in the profession. So give yourself time, don't be dissuaded. Use that time to enrich your knowledge, because you will never get that opportunity to read as much as you can now in later parts of life. As you grow more senior, you will have juniors who will be feeding you that information. They feed you excellent information, but it's not information you are gathering yourself. So at this point of time, never feel despondent that, well, I'm not making a headway. You will make a headway. But if you make a headway based on the sort of foundation which you create for yourself. Read well, keep your eyes and ears open, see what's happening, see what opportunities are coming your way. Try and teach. I felt that from my own example that teaching was a wonderful way to get work. I didn't teach to get work, no, not at all. I decided to teach for the love of teaching because I'm academically oriented. But so many of the people who started giving me work were my own students who went into the college because they had seen me teach. They had faith in me, they had trust in me, so I started working with them. One of them became my own junior. He's a very senior judge of the Bombay High Court today. So, you form associations when you teach. Teaching is a very great source of enhancing your knowledge, because you are teaching to a class like I am teaching here and conversing with all of you. So, do something like that. Attend seminars. If you hear that there is a good lecture by someone, go and do it. If you see that there is a good play, go and attend that play. If there is a good book, go and pick up the book and read the book. So law is not just about reading from statutes, but also enriching yourself, developing your mind and your way of thinking, and success will come. And above all, sincerity and honesty pay. Please remember that. Sincerity. You will find people cutting corners, doing wrong things. Don't follow that path. Because even today's world, there's value for integrity and honesty. So should we close now? Yes. Before I leave, one opportunity for the pictures. Stay where you are. I'll do it row-wise. So, come. No, quick first row. Yes, first row.